Good evening, everyone. So there's a question asked in YouTube, and we'll explain it what for it is asked, and then you can go ahead. Okay, just a minute.
Some advocates are getting order
Yeah.
exorbitant case cost, including their fees, disproportionate to advocate act. What is the remedy, sir?
Can the question repeat then?
So, విన్నారా?
No, I understood what you said.
Some advocates are getting order for
Itla వచ్చి explain.
including their fees, disproportionate to advocate act. What is the remedy, sir?
Question మీరు repeat చేసి చెప్పండి.
As far as this question is concerned, I followed the question. But please remember, this become order of the day as far as every court is concerned. Here, I'm practicing prominently in Secunderabad court also, where even if a petition is filed for reopening as well as recall of a witness, court is imposing cost of 5,000 rupees or 10,000 rupees, which is not even our fees. But please remember, unfortunately, though the High Court has imposed certain conditions that the cost should not exceed a particular figure, but the courts are doing it. Not only civil courts. I was told that in the even magistrate courts or the ACM's court, the once 311 petition is filed, 5,000 rupees or 10,000 rupees cost is concerned. I told the court once, of course, I only represented because I was the only odd man out. I told the court, sir, this is not even our fees. What cost you are awarding? The judge said bluntly, no, I'm imposing cost so that you may go on with the trial. You need not pay the cost, but you can go on with the trial. Sir, my difficulty is my party is not available. I have not briefed my client. So there is a question of cost being imposed. I'll tell you one incident which happened, sir. It is a most obnoxious incident which happened. Actually, what happened was the case was posted for further evidence of the plaintiff. And the plaintiff on the previous date of hearing, because the IAS went against him, he filed a memo, sir, we are approaching the High Court in revision. Please give us time. And the court granted time. But I think if I'm correct, it's 2nd February 2024, when, of course, unfortunately, I was held up in some other court. You know what the court did was, instead of noting that the plaintiff has no further evidence and posting it for defendant's evidence, closed my evidence and said posted for judgment. Then, after 3-4 days after looking into the proceedings, I filed the petitions for reopening as well as recall. Reopening as well as for leading defendant's evidence. But what the court did was, it said it will pass the order. In the same day, it passed an order allowing my petition on payment of 5,000 rupees cost. Please remember, no one carries 5,000 rupees to the court, and more so a person who's from the middle class. And it's too harsh to expect a party who's a middle class person to shell out 5,000 rupees. It casts aspersions on the advocate who represents the party. But please remember, whether you like it or not, we have to pay that cost. And of course, my client, what he did was he took out the phone pay and then remitted the amount to the opposite side. Please remember, the courts have got no doubt discretionary powers are there, but they say we are subject to pressure from the High Court to dispose of matters. This is not the way a matter has to be disposed of. But the only I cannot tell you the remedy because unfortunately, either the civil rules of practice or the CPC does not specify as to what amount of cost can be awarded by the court. Of course, they are acting like Hitlers today. Most of the courts, even the most inferior court, that is a junior civil court, also is awarding cost of 5,000 rupees or 10,000 rupees. And I tell you, it definitely pinches the purse, and more particularly that of a junior, who's and the senior says, you have not represented, you pay from your pocket. But unfortunately, what is happening is you don't have a remedy. Only thing what you have to do is you will have to uh, report to the High Court that this is the attitude of the court. The question is, it's $1 million question because there is a saying, who has to bell the cat, which consumes the rats. Unfortunately, these people act like tyrants. They don't even have a practice of one day in the profession. And the Supreme Court says, even if you don't have one day, also, if you get enrolled, that is sufficient, you can become a judge. So they have to be educated and they have to be made aware And the Judicial Academy, the Telangana Judicial Academy, the judges who are lecturing to these people have to make them alert and say, sir, don't impose such costs. Please remember, in that case, no person will get his cases disposed of. But this is a question which I cannot answer, sir, because the Civil Rules of Practice of the CPC does not speak about it. See, once the judge awards it, you have no other option than paying the cost and complying with the order. Only remedy open to you is make a complaint to your bar association or to the High Court saying that this is the attitude of the judge. Let the judge change his or her or their attitude. But please remember, this question is a very, very hypothetical question which I cannot answer. Only thing is, you can only make a complaint. But people like me who have got standing, we we indulge in rhetorics and we tell the judge what you are doing is absolutely wrong. But unfortunately, what is happening is the judges do not get proper training in the judicial academy. Only remedy open to you is to complain to the High Court, to the registrar, saying that this is the attitude of the judge concerned. And or you can get a resolution passed saying that the court is very, very harsh as far as imposing cost is concerned. No doubt cost can be imposed, but not such heavy costs, sir. I mean, I think I answered your question to the maximum extent possible, but there cannot be a ready-made answer for this question, sir. Thank you very much. Here, we go into the subject in the proper perspective. Section 11. Yesterday, I discussed section 10 in detail from the various facets. But and please remember one thing you have to bear it in mind. The Specific Relief Act has been amended, more particularly section 10, where the amendment has been introduced by the Amending Act of 2018. The discretion of the court is now removed. The word may is substituted by the word shall. So that means whenever a suit for specific performance is filed, the court shall enforce the agreement. There is no question of so court may enforce the agreement. So the word the discretionary part of it has gone out of the statute because of the amendment in 2018, and it has permitted itself into every section of the Specific Relief Act. So the amendment of 2018, which even in the college you must not have read, but this is the amendment which you have to bear it in mind as far as the Specific Relief Act is concerned. I was told 2 years before a question was asked as far as the this particular aspect is concerned, whether the remedy for specific performance is discretionary or absolute. But please remember, I could find students writing it is only discretionary. But now the word discretion has been removed. The discretion has been removed, and the word shall, instead of may, the word shall has been introduced. So the question is, once an agreement is sought to be enforced, the court shall enforce the agreement. There is no question of court going back and say we are going to use our discretion as far as granting specific performance is concerned. Of course, it depends upon facts and circumstances of every case while granting specific performance. This is what all I've done yesterday from various facets also. I've discussed it. Today we go to section 11, where by the way, I just discussed section 11, but I was not satisfied because section 11 deals with suits against trustees. Suppose there is an agreement executed by a trustee to sell a particular property belonging to the trust. You know, in every enactment, if you find, even in the Companies Act, there is a clause saying that the Lakshmana Rekha, which the director shall not cross. For example, the objects clause or the articles of association or the objects clause says a company is formed only for a particular purpose. It shall not go beyond the purpose which is mentioned in the objects clause. If it goes beyond it, it is ultra vires, and it can be the corporate will can be pierced, and that can be set aside. But here, that is only by the way I discussed it. But here, if a trust property is sought to be sold by some of the trustees or one trustee, the question is, as how to know whether the trustee has got power or does not have power, sir? You will have to go into the trustee deed to find out whether the alienation is permissible by the trustee. If alienation is permissible, what are the circumscribed limits within which he must act, and how he has to act, how he has to call a meeting of the board of trustees, and then sell the property. But here, section 11 says if he exceeds his powers, that is granted to him under the trust deed, the such a specific performance cannot be ordered. This is what section 11 is. This also I discussed it yesterday. Now we go to section 12, specific performance of a part of contract. What does it mean? Section 12 says where the seller is unable to perform part of the only a negligible part of the contract, but is able to perform a substantial part of the contract, then in that case, the as far as the negligible part is concerned, which he cannot perform. So the question is, if the purchaser, suppose let us say, I'll just cite an example, sir. A enters into a contract with B to supply about 500 quintals of rice of Sona Masuri. Let us say out of 500 bags, he is able to supply only 300 bags rather. Sorry, I put it that way. 300 bags. 200 bags is not in a position to deliver. Why? Because the goods are not available. Then section 12 says that part of it which he can deliver. No problem for that. But if the purchaser has paid the entire purchase money for the 500 bags before it is delivered, then the question is the buyer can take delivery of this bags which are available, that is 300 bags. And as far as the 200 bags are concerned, whatever money has paid for that 200 bags at the contract rate plus damages can be awarded. But the entire contract cannot be performed. This is what is called performance of part of the contract. That is what section 12 says, sir. I think I didn't discuss section 12. Again, I repeat this section 12. It says where the contract is entered into by A and B, and the contract is for delivery of 500 bags of rice. And let us say the seller does not have the 500 bags. He has only got 300 bags. He says, sir, I'm prepared to deliver 300 bags of rice at the contract rate. As far as 200 bags are concerned, it's uncertain when it will arrive. I'm not in a position to deliver the 200 bags. Then what the courts would do in this case is, as far as 300 bags are concerned, specific performance which are delivered, there's no problem. But as far as the 200 bags are concerned, which are undelivered, where the seller expresses his inability to deliver the 200 bags because of various reasons, then in the purchaser has paid the money even for those 200 bags which are not delivered, then he can get back the money what he has paid towards the 200 bags plus damages for the breach or violation committed by the seller. The entire contract will not fail. Please remember, part of the contract can be performed. It is already performed. Rest of the contract cannot be performed because of various reasons. For that purpose, if the purchaser has already paid the money for the remaining bags which have not been delivered, then for the breach or violation committed by the seller, he can claim the money which he has paid for the 200 bags plus compensation also he can claim. But he cannot compel the seller to supply the 200 bags of rice. Am I making myself clear to you, please? This is the heading of the section is, that is performance, specific performance of a part of the contract. Then we go to section 13. Rights of the purchaser or lessee, where rights of a purchaser or lessee against no title. Suppose, let us say, sir, I think most of you are aware of a maxim called nemo dat quod non habet. No man can pass a better title than what he himself has. Suppose this visualizes a situation where the seller or the lessor, that is the person who lets out the rent, has no title. His title is defective. His title is imperfect. Or he has no right to sell. Or he has no right to lease. అంటే ఇది ఎట్లా ఉందంటే they say అత్త సొమ్ము అల్లుడు దానం చేసి, in Hindi they say లాలా కే దుకాన్ మే నానా కే ఫాతియా. That is when the goods do not belong to you, you say take whatever you want. But have you got a right to do it? You have no right because you are not the owner, you are not the possessor, you have no title, and even your title is defective or the title is imperfect. Then in that particular case, it is said the purchaser can ask a seller to perfect his title. It's a very, very unique situation, sir. Suppose, let us say, already a contract has been entered into by the seller and the purchaser. And on the date when the transaction is entered into, the seller has no right, or his title is defective. Then in that case, the buyer can direct the seller, please perfect your title by whatever means, and then afterwards intimate me. I am prepared to abide by the terms of the contract. But please remember, if the purchaser goes ahead, enters into a contract with a seller or a lessor who has no title, accepts performance, please remember the title which he gets is a defective title. But in those contingencies, the purchaser can ask the seller, please perfect your title, please make your title clear, please take necessary steps to see that the property which you are trying to convey to me as a good title so that I get a good title. Why? Because of the maxim, nemo dat quod non habet. No man can pass a better title than what he himself has. When your lessor or when your seller himself has no title, you do not get any title to the property. This is what section 13 speaks about. So, in other words, I can repeat, if the seller or the lessor has got an imperfect title, which he cannot pass to a purchaser or a lessee, the purchaser or the lessee can direct or ask the seller or the lessor to perfect this title and to give a clear title to him. This is provided under section 13. Is it clear to you, please? These are all small sections, please. Doesn't require much explanation, provided you have a thorough knowledge of the maxim, nemo dat quod non habet. No man can pass a better title than what he himself has. Suppose your vendor or your lessor has defective title, he has no title at all, let us assume that way. Then in that case, the purchaser or the lessee, the prospective tenant, can ask the landlord or ask the seller to perfect his title and then pass on a good title to him. This is what is called, when the seller or the lessor does not have a proper title, the proper title cannot be passed on to the purchaser. This is what section 13 says. Then we go to section 14. Contracts which are not specifically enforceable. That is what is called. I think someone asked me this section 20 also. When I come to section 20, I'll try to develop on that. First one is substituted performance in accordance with section 20. What does section 20 say? Section 20. 1 minute. Sir. Section 20 says A, suppose let us say a contract is entered into by A and B. Let us say A promises under the contract to supply delivery bags. A promises to deliver the delivery bags. And let us say A does not take any steps to prepare or manufacture the delivery bags and give it to B. A contract has already been entered into between A and B. Then A, for packaging purposes, it's used. And if it's not completed, he can, before the third party with then what's up? This is what is called mitigation of damages. Please underline the word mitigation of damages. MITIGATION. Mitigation of damages. Please remember, you cannot sit in your shop. A is not delivering it. Just shed your crocodile tears and say, I've lost everything. That is Jagame, Maya, and all. When like Devadas, you can't cry in your shop. You go to a third party, either to a third party or some other agency, purchase the same goods, and then appropriate it towards your business. Then also you intimate the seller that I have done it for whatever breach has been committed, whatever violation has been committed, where A disables himself from delivering the delivery bags as per the terms of the contract. When I accept performance from a third party, I'm compelled to go to a third party or an agency and get those goods manufactured or delivered. Then whatever expenses have incurred, whatever loss has been occasioned to me, are because of the breach committed by the seller, because of non-delivery of the delivery bags, or when A disables himself from delivering it and saying that I'm not going to deliver it, then in that particular case, compensation can be demanded as far as the breach is concerned. Please remember, specific performance cannot be ordered. Why? Because The goods are not yet ready. Goods are not ready to be delivered. A has expressed himself from supplying the goods, saying that the goods are not available with me, and you accept performance by a third party to mitigate your lessen your damages and the expenses which you incur for paying an extra cost or the loss which is cost you because of non-delivery of not delivery of delivery bags, you can definitely claim compensation from the opposite side, though specific performance cannot be claimed. This is what is called substituted service. In Hindi they say, "Tu nahi to aur sahi." That is, suppose I don't get it from you. I don't sit in my shop with folded hands. I purchase it from a third party. I purchase it through an agency. I purchase it from. I look into alternate sources. Then whatever money I spent to get those goods prepared and then delivered to me, whatever loss has occurred, whatever profits I have lost, I can claim compensation from the seller, but I cannot claim specific performance. Then, but what is the condition, sir? Under section 20, to a 30 days advance notice has to be given. To whom, sir? To the seller. Please deliver the goods to me within 30 days period before the expiry of the notice, and see that the goods are made ready and deliver the goods. I am giving you 30 days time, and if you don't deliver it within 30 days, I will be compelled to purchase the goods from a third party or to another agency, and whatever loss is sustained by me because of the breach committed by you, I am going to recover compensation from you. So, what is the necessary? What is the essential requirement, sir? Under Section 20, Clause 2, it says 30 days advance notice has to be given by whom? By the purchaser to the seller, reminding him of his obligations, reminding him that you are bound to deliver the goods. And if you don't deliver the goods within 30 days period, I will be constrained to to purchase the same goods from another agency or a third person. And whatever loss or damage is caused to me because the breach committed by you, I am going to claim compensation. So this is what section 20 clause 2 says. That is, please remember, you try to minimize your damages as far as possible. Don't cry over the spilled milk, saying that the seller has not delivered the goods as per the contract. What should I do? Please remember, alternates. A clever businessman looks into alternatives. That is what is called substituted service. That's why I said, "Tu nahi to aur nu lekapothe inkovadu evodu untaru." What you mean is, I take performance from some other person. This is what is called, but the condition is I must give you 30 days notice. That is, 30 days notice has to be given by the purchaser to the seller, reminding him of his obligations, and at least say that now you have made it late, at least better than never, you deliver it within 30 days. If not, I will be compelled to take substituted service from a third party or an agency, and whatever loss is sustained by me, you will be responsible for compensation. Then, if such a contingency arises, specific performance cannot be granted. That means only compensation can be granted. Is it clear to you, please? Then we go further, sir. By any third party, he cannot claim a specific but only compensation. But Section 20A has been introduced, sir, for the first time. Of course, I'll come to this. Section 20 I've understood because this word 20 has come here. I discussed it. When I come to Section 20, I'll discuss it again in detail. Then here, what do you mean by substituted performance, sir? Here, suppose let us say, they say always in Telugu, there's always a saying, Tirupati Shavaram. అంటే మీకు క్షవరం చేసే ముందు వాడు నీకు సగం చేస్తాడు, పక్కోడికి సగం చేస్తాడు, ఆర్ he performs it in half to you and another half to another person so that he minimizes the time. But here the question is, here suppose I give a building contract to a contractor to construct on the property. Let us say the building contractor, I prevent the building contract. So let us say the building contractor does not commence construction, does not adhere to the terms of the contract, or does not even start the construction, or he has disabled himself from performing his obligations as a building contractor. Then, in that case, I cannot wait longer. I engage another mason or another contractor and get my work done. And then, let us say, I'm just taking a hypothetical example, sir. Suppose I agree to pay 500 rupees per square feet and the person new contractor who comes, he charges me 1,000 rupees per square feet. Then in that particular case, the excess amount I pay and plus the mental anguish and anger which is caused to me because of the violation, when I accept substituted service from a third party or an agency and get my work done, I can mitigate, I can lessen my problem by giving you 30 days notice, saying that at least now you have not started, start it at least now. But if the building contractor keeps quiet, does not make any preparations to perform his obligations, then I can take performance from a third party or an agency and get the work done. And if any loss is caused to me, that loss I can recover it from the opposite side. In other words, specific performance cannot be granted in this case because the question is when I've accepted performance by a third party by substituted performance because of the failure of the other contracting party from perform who does not perform his obligations, then in that case I cannot ask for specific performance, but I can ask for compensation. But what is the condition which applies, sir? 30 days clear notice has to be given, giving time to the other person to perform his obligations. And then after the 30 days period expires, I can definitely give it to a third party and also to or any agency get the work done. And whatever loss has been occasioned to me because of the inaction of the opposite party from performing his obligations, I can definitely claim compensation, but I cannot claim what is called specific performance. I'll give you one more example, sir. Nowadays, we are having a lot of reality shows and all. These reality shows, of course, I don't want to go further because some of the ladies are there. It will cause embarrassment. Rave parties are also there. Here, as far as musical night is concerned, sir, I invite a very reputed singer to come and perform. Then let us say I give her time, she enters into a contract, she expresses her willingness to come and sing in my theater and also perform the reality show. But what happens is suddenly when she gets a little bored, she goes outside and then performs in some other with some other performs another show in some other theater or whatever it is. Then in that case, there is a violation of the terms of the contract. But I cannot keep quiet because I have already advertised, I have given wide publicity, and I have also sold tickets as far as the reality show is concerned. And please remember, only stones will be pelted at me if the reality show is cancelled. Then, in that case, instead of calling, let us say, SP Balasubramanian, I call some other person to perform in the reality show. Then, before that, I give 30 days notice to the opposite side saying, sir, you have not performed as per the contract, you have violated the terms of the contract, and you have not performed as per the terms and conditions of the contract. I am going in for substituted service. That is where I am asking some other person to perform. If I have to pay more and any loss is occasioned by me because of the breach or violation committed by you, I can only ask for compensation for the breach committed by the opposite side, but I cannot ask for specific performance. I'll give you one more case, sir. That the famous case of Lumley versus Wagner, where a particular opera singer, I think opera is something like jazz show in Hollywood and foreign countries, and she was a reputed singer, that is Wagner, and she entered into a contract with an opera theater owner, that is Lumley, to perform for 3 weeks in the opera theater of Lumley, and he also contracted saying, "Sir, during the 3 years, 3 months, 3 weeks period, I shall not perform in any other theater." Here, let us say, because this lady does not turn up, this lady enters has violated the terms of the contract. I engage some other person and get the concert done in my theater. And as a result of it, suppose I have to pay her 500 pounds, the new person who is going to come and sing, I have to pay her 2,000 pounds. The excess amount which I paid, the loss to which I have been put because of the breach or violation committed by Wagner not performing at my theater during the contracted period, then in that particular case, I can only ask for compensation and also prevent her from performing in any other theater, the negative aspect of it. But the positive aspect, that is to perform in my theater alone and to keep up with the terms of the contract, that cannot be enforced. But our law is entirely different, sir. I give her 30 days time, ask her to perform, and also say that in case you do not perform, and in case any breach has been committed, I will get it done to someone to substituted performance, and any loss that is caused to me, you are solely responsible for it. In those contingencies, specific performance cannot be asked, but only compensation can be asked. That is what is called when you accept substituted performance of the contract. Then we go to, there is a new section which has been added. Of course, I'll come to section 20A, sir. Then we go to section 15. Section 15, who may obtain specific performance? This is $1 million question. Many questions were asked yesterday during interaction, saying that about privity of contract. The cardinal rule of the law of contracts is contract binds only parties to the contract or previous to the contract. A stranger to a contract cannot sue on the contract. That's the cardinal principle of the Contracts Act. But there is an exception recognized in the specific relief act by section 15. It says, suppose by any chance a person who is entitled for specific performance before the performance is done, he expires. Does the contract also end with him, sir? No. Why? Because his transferees in interest, his legal representatives, his executors, or the persons who are interested in performance of the contract can also sue as far as the contract is concerned. So the doctrine of privity of contract does not apply as far as performance is concerned, and that is what section 15 says. So anyone can file a suit. The doctrine of privity of contract does not apply. Yes, the legal representatives of the deceased, then the transferees in interest of the deceased, the assignees of the deceased, the executors of the deceased, or any other person who is interested in performance of the contract can sue as far as enforcing the contract is concerned, irrespective of the death of the deceased. This is what section 15 says. Then we go to section 16. Section 16 speaks about what is called personal bars. Not bar, what we think about. Bars means personal, where you cannot claim relief. One is substituted performance, which I've already discussed. Then incapable of performing or incapable of performing. What do you mean by incapable of performing, sir? Suppose I go to a surgeon, fix up an appointment with the surgeon for a major operation which has to be done in an emergency, let us say bypass or kidney transplant or liver transplant or let us say appendicitis or some other ailment. Then let us say I have got full confidence in a person who has special qualifications for performing the operations, because everything depends on trust and confidence, sir. We try to go to the best person available. Even after going to the best person, we take a second opinion also. Nowadays, lots of systems of medicine are prevalent. One is called Ayurveda, another is called homeopathy, another is called allopathy. But normally, people very rarely have confidence in homeopathy and Ayurveda. Though we say Ayurveda is supposed to be a native medicine, but still the cost of Ayurvedic medicine is much more than what we spend for allopathy or what we spend for homeopathy. Homeopathy, of course, it's normally called as a German medicine, but normally it emanated from India only. Homeopathy comes from India only, but it slowly went into the foreign countries. Then we have got, as far as Muslims are concerned, they have got a special type of medicine called Unani medicine. Or nowadays you are having herbal medicines also. Herbal, with herbs, they try to cure your ailment. Or you have got what is called acupuncture. Or you have got what is called naturopathy. So on, so many pathis are there. So the question is, let us say you go to the best person in the field. Same thing applies to advocates also. There are advocates who are masquerading themselves as experts in criminal law, experts in civil law, experts in family law, expert ante actor vade, actor I mean hero vade, heroine is also same person, director also is the same person, producer also is the same person, screenplay also is the same person, choreography also is the same person, playback singer also is the same person, music director also is the same person, editing also is the same person, and so on and so forth. He has got mastery over the various subjects. Then you go to such a person only, which you hear from various persons that is an expert in the particular field. Then, in that case, let us say, no doubt, no one expects that you'll fall ill or you'll become incapacitated. But on the day for performance, let us say the person gets mentally and physically disabled. And let us say he loses his power of speech and uses the power of using his limbs also for performing an operation. Then let us say no one can stop it. On the appointed day, when the operation is to be performed, the senior surgeon is not available. But can he do so, sir, because of his physical and mental ability, mental disability? Then, in that case, if you accept performance from his junior or from another person in whom your senior surgeon has got confidence, and then you cannot complain of breach or violation because it's a supervening impossibility which has occurred due to no fault of the person concerned. Then, the essential part remains to be performed or acts in contravention of the or variance who fails to perform ready. And here, suppose let us say essential terms. Let us say, sir, as per the terms of the contract, which is let us talk about more immobile property. Sir. As per the terms of the contract, you know that as far the buyer also is concerned, he also has got certain responsibilities. What are those responsibilities, sir? He must pay the sale consideration in a phased manner. Number two, that he will be that number two, he will have to pay it in a phased manner. Number one. Number two is he must be ready and willing to perform his part of the obligations by tendering the money on the appointed date which is fixed in the contract. But there are certain essential items also, sir, where let us say clearance is has to be obtained from the government for alienation. The seller is unable to get it because there is a personal bar. Then, in that case, specific performance cannot be ordered, only compensation will be awarded. Or who fails to perform ready unless waived or prevented by the defendant. Here, waiving, what do you mean by waiving? Jane do, that is, you say, excuse the lapses which have occurred or lapse which has occurred. Then, in that case, the question is there is a personal bar, such a contract cannot be performed. But one important thing you must remember under Section 16 is you have to necessarily plead and establish readiness and willingness. Unless that clause is added, specific performance cannot be granted. That means readiness and willingness under Section 16 has to be pleaded, has to be established. No doubt by the Amending Act of 2018, specific performance shall be enforced. But unless you express your readiness and willingness to perform your part of the obligation, specific performance cannot be ordered and it is a bar under Section 16. Then, sir, we go to Section 17. Contract to sell or let out property by a person having no title. Uh, then, here, sir. That's why I said this is an extension of the previous section we studied. I think Section 14 or Section 13, which says that the person who is selling the property or the person who is leasing out the property has no title at all, or he has no ownership, or he's not in possession of the property in goods. Can he do it? Even if he does it, what happens to the purchaser? Purchaser also will get an imperfect title. So that is the reason when the seller or the lessor has no title, he cannot pass a good title, or he has got an imperfect title, he cannot pass a good title to the purchaser. Here, that is the no, by vendor or any person who has knowledge of that he has no title, vendor he enters into a contract, no specific performance. Here, there is one clause in the Transfer of Property Act section 6A. 6A is, I'll tell you what it is. 6A speaks about what are the properties in the transfer of property, not in specifically, please. It says what are the properties that cannot be transferred. First section is section 6 clause A, which says a space succession is SPES space succession is SUCCE SSINIS. That is, a person or an heir apparent who has only got a mere chance to succeed to the estate of the deceased or the estate of his father or some other person, he cannot transfer it or he cannot lease it out unless and until he gets the property. That is what they say. I told you also. That is, let us say I'm expecting the person, that is the father or guardian, whomsoever it may be, to kick his bucket as soon as possible. And if he kicks the bucket, I am going to get the property, and this property I'm going to convey to you, or this property I'm going to lease it out to you. Please remember, on the day when the contract is made, do you think that A has got title? No, he has only got a chance to succeed. It may or may not happen. Why? Because the person whose property wants to succeed may not give the property at all to him. He may give it to a charitable institution, or he may give it to a church, or he may give it to the Mother Superior, or he may give it to the Madhadipati, that is His Holiness the Shankaracharya, or to various ashrams which are there. He changes his mind, or he gives it to an old age home, or he gives it to a home for the disabled. So in that case, till he gets a title, the person who enters into a contract, till he gets title to the property, that property cannot be transferred. Even if it is transferred, only a chance of an heir apparent to succeed to the property cannot be transferred. Even if it's transferred, it is no transfer at all. It is not enforceable under the law. Then, vendor, though entered into the contract believing that he had good title to the property, cannot at the time fixed for the contract by the court or sale or lease give the purchaser or lessee a title free from reasonable doubt. Your transferor himself has no title, sir. He has no title to the property. He has no right to lease. He has no right to sell, and he cannot pass a good title to you. The purchaser also does not get title, even assuming for a moment the purchaser goes for specific performance in the contract. Specific performance will not be granted for the simple reason your transferor has no title to the property. He cannot sell, he cannot lease, he cannot transfer the property to you. This is a personal, but that's why I gave you the example of Section 6A of the Transfer of Property Act. A chance of an heir apparent to succeed to the property cannot be transferred. Are you able to understand this? Then one more instance I can give you, sir. Of course, it's in the Transfer of Property Act only, when the Section 6 itself. A servient heritage, a servient, SERVENIENT, SERVENIENT, SERVENIENT. Servient heritage cannot be transferred without the dominant heritage, DOMINENT. So, a servient heritage cannot be transferred without the dominant. What does it mean, sir? That means, suppose, let us say, by prescription, by usage, I acquire an easementary right over the neighbor's property for long usage of time. Then, in that particular case, I cannot transfer that particular easementary right to a third party without transferring the ownership of my property. The question is, even if that is transferred, it is invalid. It cannot be done because you have no right to sever the property. The proprietary rights remain with you, but the other rights you transfer it, that is not valid, and no specific performance can be granted. Then, time and place of contract, section 45 to 50, that is same applies to movable. As far as movable property is concerned, hire or sale. Hire or sale. It says that as far as hiring is concerned, this is very, very common now, sir. Hiring is hire purchase. You go to various furniture shops, they say, sir, or you go to what is called various shops and say, sir, you need not pay the entire amount. You can pay the EMIs, give the PDCs. PDCs means post-dated checks for the period 48 installments or 60 installments or 75 installments, as the case may be. The question is, suppose your hirer has no right. He sits in the shop only as the friend of a person. Can he transfer title to you? Can he transfer the goods on hire purchase? No. Why? Because once he himself does not have right, the purchaser also will not get any rights over that. Then sale. As far as sale is concerned, suppose the mobile property is sold, what is sold should be your property. It should not be some other's property. Where you try to enjoy possession of someone's property which is given to you on lease, let us say, that cannot be transferred to a third party, and this is what is called Section 17. Then we go to Section 18, sir. Non-enforcement except with variation. Non-enforcement except with variation. What do you mean by non-enforcement except with variation? That means, let us say, the vitiating elements of contract are present, and at the time of the contract, the seller has been induced. The buyer himself prepares the document, and then the seller has got five muddies, five shops. But the intention of the seller is to only sell two shops. But in mischievously, the purchaser gets it incorporated in the agreement that five shops are agreed to be sold. Please remember, then what happens is, once the mistake is detected by the seller, he executes a supplemental agreement saying that only two shops are agreed to be sold and not five shops. Then, if a suit is filed for specific performance based on the old contract that five shops have to be sold, but it has been varied by a supplemental agreement or a subsequent agreement, then the question is, only this contract is enforceable only with that variation and not on the basis of the mistake that has been committed in the original document. Then, sir, there are various cases, sir. One of the cases was court cannot frame a cannot. Please remember. See, one of the cases, Kroom versus Ledyard. In that, what happened was there was a contract between the parties. There was a contract between the seller and the purchaser. The contract has to be implemented, contract has to be enforced, contract has to be followed and decided by the court. Let us say the court cannot itself frame a new contract for the parties and then enforce that contract. The contract has to be interpreted in the letter as well as in the spirit as it originally stood. In the Kroom's case, it was said court cannot construct a contract for you. Court cannot construct a contract for the purchaser or the seller. The duty of the court is only to enforce the contract as and when as it is framed. The object provides a legal result when it does not produce variation can be established. So please remember, it is for the defendant to establish, prove that there has been a variation in the terms of the contract. The contract as it originally stood has been changed, altered, or new clauses have been added, or it has been novated, rather I put it that way, to a supplementary agreement. Then the question is, the contract cannot be enforced without the variation being taken into consideration. That is what this particular section deals with. That is, in Kroom's case, it was said, court will not construct a contract for you. Court's duty is to interpret the contract as it is made, and the court will not construct a new contract. But nowadays, if you see the judicial pronouncements in the Constitution, what is said is there is a separation of powers. The powers of the legislature is to enact a law. The powers of the executive is to implement the law. Powers of the judiciary is to interpret the law, isn't it? These are the three duties which are covered under the Constitution, or what is called in Telugu as Rajyangam, or in Hindi it is called the Samvidhan. But what is happening is the courts today, the judiciary has become hyperactive. That is, in other words, they are embarking on the functions of the two other organs, that is the legislature as well as the judiciary. And the judiciary, whenever, for example, if there's a NGO strike or an RTC strike, or there's a student strike, or there's a strike by doctors, or there's a strike by advocates, or there's a strike by judicial officers, or there's a strike by someone else, so on and so forth. Executive has not taken any action. Executive is not acting in the matter. Executive is acting in a partisan matter, or it is not possible to for conciliation or to settle the issue, then in that case, what the courts are doing is they are trying to settle the matter by pill or what is called public interest litigation and try to embark on the activity of the executive and try to lay down new principles to settle the matter. Please remember, judiciary is overcrossing its limits by embarking on the powers of the executive. In the same way, when a contract, I'm trying to give an analogy, sir. When a contract is made, contract has to be implemented, contract has to be enforced, and contract has to be followed as it is laid down. But the court cannot construct a new contract for the parties and embark on the trial of the case. So I think with this, we will. Tomorrow, I shall discuss about section 20, that is substituted performance, and the schedule which has been introduced as far as 20 is concerned, and even section 19, when compensation can be granted and specific performance can be refused. I will stop with section 19, please. I'll only deal with that section 19 and then stop. Any person suing for specific performance can also ask for compensation for breach in addition to specific performance. So whenever a breach has occurred, whenever a violation has occurred, in addition to specific performance, even compensation can be asked for belated performance or refusal to perform the contract. In any case, the court decides specific performance cannot be granted. In case of breach, compensation can be granted. That is, I gave you that example also, saying that files a suit for specific compensation. A suit for proper contract is violated, compensation is granted. Suppose I said there's a contract for 500 bags of rice to be supplied and only 300 bags are available. Regarding the 200 bags, it cannot be performed due to various reasons. The question is, court will award only compensation, but specific performance will not be granted. Then in any suit, court decides specific performance shall be granted and it is not sufficient. Suppose, let us say, the breach is so dangerous and so extra, then in that case, in addition to awarding specific performance, the court can award reasonable compensation also for the breach or violation. Suppose, let us say, in one case that become not performed, compensation. Suppose, let us say, a company, a body corporate passes a resolution to allot shares to a particular person. Then let us say the resolution is not implemented, the person concerned is not given the shares as promised, but the shares have been allotted to some other person. In that case, specific performance cannot be granted because all the shares have been sold out, it has been already contributed. Then in that case, the person who does not get the shares, he can ask for the implementation of the resolution and ask for compensation alone, but specific performance cannot be ordered. That is what section 19 deals with. Then we'll deal with section 20 and other sections tomorrow. Now the interaction period starts.
Yes. Is anybody any questions? Mala,
Murlidhar Bala.
Sir, good evening, sir.
Good evening.
Happy that I met you personally today.
Yeah, I saw you for the first time. I was telling my colleagues also. Yes, sir.
Yeah, I'm happy to, and I congratulated you. It's a nice thing that I had met you for the first time. I was very happy, and we'll keep on meeting there.
Thank you very much.
In this, sir, whether contract act, whether it is the oral contracts, what are the effect of a oral contracts? Or these contracts have to be registered in the sub-register office to enforce
Sir,
under specific relief act.
Sir, as far as the specific relief act is concerned, oral contracts are not registered. Even written contracts are not registered. But it is optional. If you want to get it registered, you can do it. But as far as companies are concerned, all charges or all contracts has to be notified to the registrar of companies who makes entries in his books called the charges register or contracts entered into by the company. And it has to form part of the company's records or the minutes have to be passed, but no need of registration, sir.
Oral agreements.
Oral
What is the
agreements.
proof of oral?
Please remember, written any problems. Where is the question of oral agreements?
Uh,
See,
so
what,
written agreements, is it required on the stamp papers or simply on it?
yeah, normally it is written on a stamp paper, 100 rupees stamp paper. But after 2015, it is 200 rupees because all agreements or contracts have to be engrossed on 200 rupees stamp paper, non-judicial.
Sir, have a look at tomorrow when it comes, 21 of this Specific Relief Act, subsection 4. We say that determining the amount of any compensation as per the 73 of Indian Contract Act.
Indian contract Act section 73 is quantum merit. Quantum merit is so as to the extent of the work done, a person is entitled for compensation. It has to be evaluated. It has to be valued, and a valuer has to be appointed for that to the extent of the work done, taking into consideration the measurement book and the work register, which is kept and maintained by the contractor as well as your owner. And according to that, it has to be evaluated by an expert, and then a value has to be given, and according to that, compensation will be fixed. That is what is called, if I have to put it precisely, it is called the doctrine of quantum merit. Quantum MERUITT. Quantum merit.
Thank you, sir.
Right, welcome. Huh? Any questions, please?
Sir, when you write for the property dealing, for the advance payments and all, it will be very good.
Pardon?
Not as per the market, not as per the market card payments, card rates. Then what will be the problem? It will be on the stamp paper.
Which
They
one?
go back, then what is the,
Which one you are referring to, sir?
so sale of agreement of lands in plots, they write it in a very high amount in the beginning.
Right.
After that, when they register it, they tear it off and they'll do as per the card rate of the.
See, that is
that
is what is called the there is a parallel economy also prevailing, sir. What they do is the book value is there and the private value is also there. The book value is according to the books kept and maintained by the registrar. You pay. You mention this sale value as whatever consideration, whatever is mentioned. But private value is something different, and that is the reason why the black money circulation is very, very prevalent, sir. Private sale, I take the black money first itself, but no receipt is given for that.
How to recover when it goes back?
You cannot recover, sir. Black money, what you pay, cannot be recovered.
Not black money.
Yeah.
It's a black money. I have agreed to for a specific amount.
Yeah.
This for the amount, I want to sell it for this amount.
Yeah.
Give the advance to him.
Yes.
Then what happens if he goes back? If he doesn't perform that registration?
Yes. Yes.
Can we recover back that amount given by
that the question is there are two remedies open to you, sir. One thing is you can ask for refund of the money whatever has been paid, or your first relief is you can ask for specific performance of the contract, and in the alternative, in case the specific performance cannot be done, under section 22 to return the money which has already been paid with the interest thereon. That's why alternate and inconsistent pleas can be taken, and that is one of the judgments of Justice Narasimha Reddy, who says in equity, if you are going to ask for refund of the money, then in that case you must plead it under section 22. If you don't plead, you cannot get that money. Gone are those Harishchandra Rojulu Poindi. Now it is question is, unless you plead, unless you claim, the court is not bound to grant you that money. Am I making myself clear to you, please?
Very clear.
Induru Ram Prasad.
Good evening, sir.
Good evening.
I have one doubt. During agreement subsistence of removable property,
Yeah.
seller sold to another person.
Right.
Can I file specific performance?
Sir, I'm coming to that in section 20, sir. Suppose there is a violation of the terms and it has been sold to some other person by suppressing your earlier agreement, Then in that case, you want to file for specific performance. Whoever the subsequent purchaser is, you can make him also a party and ask for a relief that 1 and 2 have to join in execution of the document unless that person to whom it is sold has acted in good faith and for consideration without notice of the earlier agreement. But the question is, when you are able to prove that the agreement earlier was subsisting or in force, the question is the breach cannot to be committed. But even if it's committed, the court will enforce it not only against your vendor, but also the subsequent purchaser who knows about the earlier agreement but still enters into a contract. Am I making myself clear to you, please?
Yes, sir. What is the provision? Provision
19.
Section 19, sir.
Yes, sir.
Okay. Can I file order 7?
Order 7
Section-
only you filed, sir, but the provision under which you have to look is section 19.
Section 19.
Yes, sir.
Okay. Thank you, sir.
Welcome, sir.
Sir, good evening, sir.
Yes, Nokia.
Hello.
Yes.
Sir, may I explain section 12?
Section?
Section 12 of basic
Just a minute. Section 12. Section 12. Yes. That is a specific performance of part of the contract. Suppose, let us say, A agrees to supply 500 bags of cement. He is not in a position to supply 500 bags, but he supplies only 300 bags. 200 bags are not supplied. He expresses his inability to supply the 200 bags immediately. Then the purchaser writes to the seller, gives a notice, you agreed to sell me about 500 bags of cement or whatever it is, but you have supplied only 300 bags. What about the 200 bags? I've already paid you the money. Then in that particular case, whatever money I've paid to the other side, plus the damages which has occurred to me because of the violation or because of the breach, I can only claim compensation, but I cannot compel him to perform the unfinished work. Am I making myself clear to you? You can accept
Thank
what
you.
is called part performance.
Thank you, sir.
Welcome.
Sir, one more is there. Sir, doctrine of quantum merit.
Doctrine of quantum merit. That is laid down in section 73 of the ICA, that is Contract Act, where it says to the extent of work done, provided it is evaluated, valued by an expert, the quantum of work done, the person who has done it is entitled to be paid for that quantum which he has done, though he has not finished the rest of it.
Okay, thank you, sir. Understood.
Zoom? Next, please. Mr. Avinash. Mr. Avinash. Who is the Zoom user, please? Yes, sir.
Sir, good evening, sir.
Good evening, madam.
Sir, rental agreement రాసేటప్పుడు how much stamp paper to be used, sir?
See,
100 or 200, sir?
Madam, one thing.
Rental
When you write a
rental
rental agreement, it should be on a stamp paper of 3% on the annual rent, if it is for 3 years. But if it is beyond 3 years, it is 5% of the annual rent that has to be on stamp paper, and it has to be compulsorily registered because of 17B of the Registration Act, which came into force on 1st July 2001 by the Amending Act of 2001 as far as that is 17B of the Registration Act.
Thank you, sir.
Next, madam. Next. Mr. Alok. Mr. Alok.
Good evening, sir.
Good evening.
Am I audible?
Yes, sir. Yes, sir. Go ahead.
Sir, I want to know how many topics you have covered till now, because your lecture is so very good for me.
Sir, please be a bit loud, sir. How many?
How many lectures you have covered till now? I mean, how many topics you have covered till now?
Yes, sir.
Because I got to know yesterday.
Yes, sir. I have covered cross-examination in civil matters, cross-examination in criminal matters, then civil procedure code, then sale of goods act, and now we are dealing with specific relief act, sir. I've asked my admins to, I think it's available on YouTube. You can download it and then get the information also, sir.
Sir, if possible, please share the link because
I think perhaps you have joined later.
yes.
I will,
From yesterday I joined.
yes, sir. I mean, it is available on YouTube, sir. Any doubts or questions on that, you are free to ask.
Thank you, sir. Thank you so much. Please share
Because
the
I
link.
cannot roll back. Only thing is, once we finish my quota, then I'll try to come to that, sir.
Okay, sir. Thank you.
Welcome, sir. Mr. Sam from Mumbai.
Yes, sir.
Yes, sir.
Sir, yesterday you have clarified regarding the partition that has to be made through will date
Yes.
going to mutation done in either in panchayat and DHFC or
Our municipal
whatever
corporation.
it may be.
Yeah.
But it cannot be done in sub-register. That's what you said, sir.
Yes, yes.
But I was just thinking over it. How about
If you want to get it done through sub-register, there is one procedure, sir. All of you who have got the respective shares can enter into a partition deed, get the partition deed registered, because under the partition deed, you only pay on one share. The larger share, you pay the stamp duty, not on the entire shares. That is one possibility. The second possibility is giving effect to the will executed by the deceased. You people can enter into a family settlement between yourselves, saying that whatever has been allotted, you confirm the allotments made in the will. There are two options open to you.
next one is gifted deed, no, sir?
As far as gifted deed is concerned, that is different, sir. Gift deed cannot be done there because if specific allotments have been made. The question is, you can give effect to it by confirming the will and say these are the allotments made. This share goes to A, this share goes to B, this share goes to C, that share goes to D. But the stamp duty which you pay is the larger share which remains. On that you pay the stamp duty. And you can also get a family settlement also done. The stamp duty is very, very less because it's within the same family. 1% or 2% is collected, sir. If you want a registered document, perhaps.
Okay, sir.
Yeah. Any more questions, please?
So the rules of civil criminal rules and civil rules of practice different from state to state or entire Indian
No,
state?
it differs from state to state, sir, because as far as, I'm sorry, CPC is not our state enactment. I'm sorry, sir, very sorry. It is a central enactment. So the civil rules of practice also, which is enacted, though the states have got the option of framing their own rules, but civil rules of practice, model civil rules of practice is framed by the central government itself. Yes?
But sir, I have noticed in Maharashtra there is like Maharashtra Housing Act has also been there, sir. So what is that? It is a state kind of law,
It's
right?
a state enactment, sir.
State enactment.
Yes, sir. For example, Court Fees Act is there. We have our Andhra Pradesh. We follow the Andhra Pradesh Court Fees Act, which has been adapted by our Telangana. So the same act applies only with a different nomenclature. That's all.
On all the acts of Andhra Pradesh have been taken over by Telangana.
Yes, sir. Exactly.
Special acts
Adapted.
adapted by Telangana.
Exactly.
Now, from yesterday, sir, now they have removed metropolitan word from metropolitan magistrate.
Yes, sir.
They JFCL, Judicial First Class Magistrate.
That is only in districts, sir. That is only in districts. They call it as JFCM. But here we call them as...
No. Yesterday, the groups of advocates that metropolitan word has been taken away from city also. They are going to do
now it's JFCM. JFCM.
JFCM everywhere in even city also.
Sir, my colleagues are well versed with that, sir. I only conduct trials and conduct arguments, that's all. I don't go into this.
I just saw the group so that I want to just...
You are well informed about it. Because you must know that I am already finished 52 years. My mind has become a bit rusty. I just stand enlightened by your submission, sir. Thank you very much. Satya from Karimnagar.
Sir, good evening, sir.
Yes, sir. Good evening.
Sir, regarding the specific performance act, whether that unregistered agreement sale is also can be admitted as an evidence, sir.
Sir, unregistered agreement of sale, nowhere it says. Now, of course, after 17B has been introduced, all agreements after 2001 has to be in writing and has to be registered. It cannot be looked into for a primary purpose, but for a collateral purpose to know the transaction, relationship of the parties, and the nature of the transaction alone, it can be gone into. But for the main purpose, it cannot be used. The collateral purpose is laid down in section 49, that is of the Registration Act. For that purpose, it can definitely be looked into, but not for the primary purpose.
So kindly is that what is the collateral purpose, please?
Collateral means to know the nature of the transaction, to know the relationship of the parties, who stands as a seller, who stands as a purchaser, what is the property that is covered by the document, what are the boundaries of the document, and then what is the consideration that is agreed to be paid by the party. But the question is, if it is not registered, it is not fatal. Only thing is, after 2001, every agreement has to be registered.
So whether it can be impounded after that?
Impounding, there is a judgment of our High Court of Justice C.V. Ramulu. They say the impounding does not cure the defect. I think if I'm correct, it's 2015 AP. I think at that time, Mr. C.V. Ramulu was there. He said even impounding is done. Impounding has no effect.
Oh, sorry.
I think I got that citation also. I'll give you that citation. Sir, the rulings book.
Thank you, sir.
One
Thank
minute.
you, sir.
Just be on the line.
Sir, thank you, sir.
Rulings book. అది కాదు ఇది రూలింగ్స్ బుక్ అనుకుంటా. అది కాదమ్మా, అది ఇంకోటి కింద ఉంది అది. One minute, sir. Be on this. That is 2009.
Sir.
2 ALT.
Sir.
662.
Sir.
Single bench.
Sir.
That was yes, sir. That is interpretation of section 33 of the Stamp Act.
Sir.
Yes. That's it.
Sir. Thank you, sir.
Welcome.
Sir.
Any more questions, please? Will you wind up? Yeah. Any more questions?
Sir, one question, sir.
Yes.
Can we seek a refund of earnest money without seeking cancellation of the agreement of sale?
Without asking for cancellation. See, this is equitable relief. You can either ask for return of the advance money or you can ask for cancellation. You can ask, in addition to cancellation, you can also ask for return of the earnest money, sir. Both can be claimed in the alternative.
What happened is that the subject matter of the case was already sold away.
Then in that case, you got the doctrine of unjust enrichment, sir. That is, you cannot have the money and still do certain acts which are inconsistent with the contract. But under the doctrine of restitution, whatever monies are had and received, you have to return it back to the person concerned, sir.
Then the judge is asking for file a petition initially to file a petition to dispute the contract and then ask the
That is 27 and 28 of the Contracts Act. Rescission and contract. That is, as far as specific relief act itself is concerned, you can ask for rescission and in the alternative for the return of the EMD or earnest money which has been paid, sir.
Initially, after rescission of the contract
and ask for the repayment of the money, whatever has been paid. Which
amount we have to pay court fee?
But you pay court fee only on the contract, sir. But the return of the money, you need not pay court fee because you pay court fee only on the higher relief. That is under section 6 of the Court Fees Act. That is multifarious suits.
Then that is the sale consideration.
Whatever you have paid plus interest.
Oh.
Yeah. Thank you, Mr. Vasantrao. Mr. Venkat? Mr. Venkat, please go ahead.
Sir, I have some engagement. So I just say thankful to the session, sir.
Thank you.
Which we had.
Yes.
Thank you, sir.
Yes, Gauzia. Mr. Satya from Karimnagar.
Sir, I'm sorry, sir. One more doubt, small doubt, sir.
Yeah.
Sir, one small doubt, sir.
Yes, sir.
Sir, regarding to this, recently the Supreme Court, I think that is given a judgment regarding to at the time of the admission of a document, suppose for example, a unregistered document like that.
Right.
If objection is not made by the other party, the court considers it. It cannot be objected by the later stage.
That is under section 35 and 36 of the Stamps Act, which says if the objection has to be raised, it has to be raised at the time when it is marked. If it is not raised at that time, it cannot be raised later.
Even also, one of the high courts also reverted the decision taken by the trial court. The Supreme Court said that even the high court is also not having the power. Whatever the decision taken by the presiding officer is the final. So it was, since it was not objected by the other party, the court has taken the and admitted as an evidence and marked it as an evidence.
Section 35 and 36, you kindly refer under the Stamp Act, sir. Once a document has been allowed to be marked, no objection is raised. Then in that case, the objection cannot be raised later.
Even court also not taken into cognizance that it is not registered also.
Sir, you cannot attribute knowledge to a person who has no knowledge, sir. I'm putting it that way.
Sir, thank you, sir.
I told a particular judge, if you do not know the law, go home and read the book.
Sir, thank you, sir. Thank you, sir.
Welcome.
Thank you.
Any more questions, please? Mr. Murugesan. Mr. Murugesan. Yes, next. What about you, Mrs. Gauzia? You are now clear in your mind. There are no doubts lingering. I think we'll wind up with this, and tomorrow we'll meet at the appropriate time. Thank you.
Thank you very much. See you again tomorrow.